My name is Dana Long. I'm the due process attorney with the Indiana Department of Education. I've been with the department for 22 years now. Before that, I worked for Indiana Protection and Advocacy Services. So Kristen asked to have a presentation on discipline. Last year, Tracy Tetrick did the presentation on due process procedures that talked about complaints, mediations, and due process. So the presentation today touches on both of those, but we're going to start with the discipline first so that we can hopefully have time to address that topic more thoroughly. And then after the break this morning, we'll continue on with the due process procedures and also introduce you to our electronic online filing procedures for due process for complaints, hearings, and mediations that we call ICHAMP. And Stephanie Sloan will talk to you about that. She's our guru on that she's in charge of all things ICHAMP along with Kim Payton. So, oftentimes I think when we think about student discipline, we're talking about punishment. We're talking about suspending or expelling a student. Back in the day when I was in school, we also sometimes paddled students. You know, they'd get sent to the principal's office. That was the discipline. But discipline should not be punishment, okay? It's the dictionary definition from the American Heritage Dictionary is it's the training that's expected to produce a specified character or pattern of behavior, especially that which is expected to produce moral or mental improvement, or it's the controlled behavior. When you talk about somebody being disciplined, they're controlled in their behavior, they're focused on what they're doing, they're getting good outcomes, and this is what we need to be helping our students to do. When we talk about disciplining a student, we should be providing education and support. Discipline is an educational process. Okay, some of this stuff here in talking about school corporations, this particular statute does say school corporations. It doesn't say charter schools. The pupil discipline statute is found in Indiana Code 20-33-8. Only 3 sections of that that chapter specifically apply to charter schools. However, I think the argument can certainly be made that generally, you know, schools stand in loco parentis to students. That means you're there in place of the parent. You have authority over the student. You have the right to discipline students and would have qualified immunity for the actions that you might take, so long as what you're doing is reasonable. You kind of can't go off and do something that the average person would not think was appropriate. Okay, the 3 sections about in the discipline statute that do apply to charter schools have to do with the procedures for suspension, expulsion, and judicial review. This particular section does not apply. However, I think it would be a good idea that a school have a discipline policy in writing, that parents and students are made aware of it, that you set forth, you know, some sort of progressive discipline that might be appropriate for all students. What are the grounds for suspension and expulsion? Okay, you do have to have procedures for both suspension and expulsion. Those 2 sections do apply to you. And the rules also set forth maximum terms of suspensions or expulsions that would apply to other students, generally. Now, when we talk about special education students, which is when I end up seeing some of these situations if a parent files a complaint, not only for special education students do you have to follow the rules of Article 7, which are Indiana's special education regulations, but your procedures must be compliant with the pupil discipline policies, statutes. And when we look at removing a student, removal for part of the day is considered a removal for a whole day. So if you turn around and you're having problems with a student and you call the parent mid-afternoon and say, hey, Johnny's just really acting up and we can't do anything, please come and pick him up and take him home, that counts as a removal. That counts in essence as 1 day of suspension when we start talking about how many days you can suspend a student with a disability without providing educational services. If a student's IEP addresses a short-term removal such as that, and that's in the IEP, then that does not count as a day of removal. However, I would point out that this shouldn't be a regular occurrence. Okay, we have seen some situations where it says in the IEP that if a student acts out, the school will do A, B, C, and D, where D is, after we've done all these other things and we tried these things, then we're going to call the parent, and the parent's going to come and pick up the kid and send the kid home. Okay, parent agrees to this in the case conference. That all sounds fine and good, but you know what? What are the expectations here? The parent is not expecting that they're going to come and pick up their kid every day. Okay, everything starts along fine. A couple weeks into the school year, you call the parent, and the parent comes and picks up the kid. Then another week later now, you have another day where you call the parent and the parent comes and picks up the student. Then it progresses and it gets to the point where it's a couple of times a week, it's 3 times a week, then it's almost every day. Okay, when you think about what discipline is, and when you think about, as you'll learn later, talking about functional behavior assessments, what is the function of the behavior? What is the kid learning here? The student is learning that I don't want to be at school, all I have to do is act out and I get to go home. Okay? Student has learned, but not what we want the student to learn. So if you find that you are trying to send the student home too many times, you need to probably do an FBA, look at the student's behavior, what is going on, what is the outcome that the student's trying to give, and what educational steps can we take? How can we teach the student different behaviors and get different outcomes, and reconvene the case conference, reevaluate the student, reconvene the case conference, and make some revisions here, because continuing to send a student home every day or several times a week is not educationally appropriate for the student. Okay, sometimes schools will impose an in-school suspension and then say, well, we didn't send the student home, it was not an out-of-school suspension, so they're not counting this, the school is not counting this as a day of suspension for a student with a disability. That's not necessarily going to be the outcome. You know, back in the day when I was in school, a student that got an in-school suspension went down to the auditorium, in one of those big rooms in the back of the auditorium. They sat there with all the other kids that were serving an in-school suspension, and there would be a teacher in there that was just to maintain order and to take attendance, make sure the kids stayed there and didn't go wandering off. Okay? No instruction is going on. Some kids are sleeping, some kids are playing games, some kids are reading or doing homework, but nobody is making students do anything in particular other than stay in this room. That is still considered a day of suspension as far as we're concerned in special education. In-school suspension will not be considered a suspension or a removal if the student still has the opportunity to make progress in the general education curriculum to the extent that's in his IEP. He still needs to receive the special education and related services that are in the IEP, and he has to have the same opportunity to participate with non-disabled students as he would if he were not in the in-school suspension. Okay. If a student is having behavioral issues or concerns, or you suspect that the student might, the case conference should be addressing these concerns early on. Let's not be reactive and wait until after they happen and then what do we do, but we should be proactive about this and look at what kind of educational services that we're going to provide. Inappropriate behavior, anything that interferes with the education of either this student or other students, you need to be addressing that. And we need to consider a functional behavioral assessment and developing a behavior intervention plan. throughout these slides and throughout special education, and you will find throughout the day here as other people talk, there are a lot of acronyms that are used. I will try to make sure that I explain what those are, but if I use an acronym that you don't know and don't understand, please feel free to raise your hand and ask me to explain, because in special education we use a lot of acronyms. FBA and BIP being two of those. Many years ago when I first started Indiana Protection and Advocacy Services, my very first day I was talking to one of the directors, and this is part of the orientation, telling me about what the Client Assistance Program at Indiana Protection and Advocacy Services did. I lost, in my mind, half of what he was saying because he was talking about the IRS this and the IRS that, and to me the IRS is not a name you want to be hearing about. It's the Internal Revenue Service that we all think about on April 15th. And I am trying in my mind to figure out what I've got myself into, because I didn't want anything to do with taxes. I didn't come here to do that job, and yet here he is talking about the IRS. And by the time I realized that to him the IRS was Indiana Rehabilitation Services, I lost the gist of what he was saying. So I don't want that to happen to any of you folks today. If any of us use acronyms that you don't know, please ask and we'll try to explain that to you so you understand what we are saying instead of trying to spin around in your mind and figure out what we're talking about. So functional behavioral assessment, I'm not going to go into in detail because you'll have other people talking to you about it, but it is a process. It's an evaluation. Remember, for our special education purposes, it is one type of evaluation. So we're going to try to identify patterns of students' behavior and what the purpose of that behavior is. Because it's an evaluation, you do have to have written parental consent to perform the FBA. It is part of the evaluation process for any student suspected of having an emotional disability, and it is also an integral part of a BIP. I see tons of IEPs of students that have BIPs, behavioral intervention plans, and they've never done an FBA. But when you go back and look at the definition of BIP in Article 7, it's supposed to be informed by a functional behavioral assessment. Okay, there are certain times when an FBA is required. If you're looking at suspending a student for in excess of 10 days this is cumulative during the school year, or if you are considering expelling a student, you have to do an FBA unless you've recently done one. But there's no requirement that a student be facing disciplinary action before you conduct an FBA. Like I said, it should be done to help inform the development of a BIP. But a parent can ask for an FBA if they are concerned about the student's behavior. A teacher may say, hey, there are some behavioral concerns here for the student. What can we do to address this? And let's do an FBA. Again, if the school is wanting to initiate this, you need to notify the parent and get parental consent before you do that. We have seen some situations where schools try to say, well, we don't have to do an FBA because we're not looking to suspend or expel a student. But again, it is an evaluation process like any other evaluation and can be done at any time. Okay, the behavior intervention plan, it needs to be developed by the case conference. Oftentimes schools develop it on their own. That can be okay so long as you take it to the case conference and let the parent have an opportunity to have input into that. Oftentimes I see situations where the case conference says, well, we've agreed the school will develop a BIP. So it's done backwards that way. Again, make sure that the parent is notified, informed of that, has an opportunity to participate in the process and have comments, and that you're open to revising that if the parent has some concerns that are valid that should be taken into consideration. And again, the BIP, by definition, in Article 7, it's a plan that has to be agreed upon by the case conference, and it's going to describe the pattern of behavior of the students that's impeding that student's learning or the learning of other students, and the purpose or function of that behavior as identified in the FBA. It's going to describe the positive interventions and supports and other strategies, and I've emphasized that here because too many times the BIP is nothing more than a system of punishments, of escalating punishments. We start out, if the student does this, the school's response is this. If the student continues to do it or does something else, then the school does something more. We impose more and more. We give a verbal reprimand. We set the student in the corner. We remove the student from class. We remove the student from school. We do these progressive steps that are reactive rather than being proactive and teaching and providing positive behavior strategies to help a student learn appropriate responses and how to cope. So if applicable, you're going to talk about the skills that are going to be taught and monitored in an effort to change this pattern of behavior. Okay, again, removals, Article 7 uses the terms removals. That comes from the federal regulations for the Individuals with Disabilities Education Act. That's the language that is in the IDEA regulations. Some people have described the first 10 days that you might remove a student in a school year as a FAPE-free zone, where FAPE, F-A-P-E, is free appropriate public education. There is no requirement that during the first 10 instructional days that a student has been removed from school, a student with a disability, that educational services be provided to that student. However, if you are seeing a pattern, and if you are repeatedly removing a student, I would suggest you not just wait until, oh, the student's been out 10 days, now what do we do? Or, student's been out 10 days and now we're looking to suspend the student again and we're going beyond that 10 days and now you're scrambling. You should be starting to address that behavior sooner, okay? Do we have a BIP? Have we looked at the student's behavior? You know, did we do an FBA? And again, remember that a removal for part of the day constitutes a day of removal. If a student has been removed for more than 10 cumulative instructional days in a school year, then you have to determine if a change of placement has occurred. There are a couple of things that are going on here. One is, beyond 10 instructional days, if you've removed a student, you have to provide education, okay? And that education needs to match the services that are required in the student's IEP. But when we talk about the next steps of looking at whether or not we conduct a manifestation determination, most schools probably, when we hit this 10 days, regardless, they're going to consider that any further removals would be a disciplinary change of placement. However, when you look at the requirements in Article 7 and in IDEA regulations, there are a couple of criteria you look at. So first of all, disciplinary change of placement. If you have more than 10 consecutive days, that is, by definition, a disciplinary change of placement. But what about the situation where the student has been removed multiple times for shorter periods of time? Let's say the student got in a fight on the playground and you suspended the student for 3 days in September, okay? Then in October, the student mouthed off to the teacher and got another day of suspension. Then the student was fairly well behaved, and then January comes back after winter break, and now the student is refusing to, follow a teacher's instruction and gets another 2 days suspension. And then another couple months later, you're looking at another 4 days suspension for some other activity. At some point, we've gotten beyond our 10 days. So now what do we look at? Is this a disciplinary change of placement when we're going to want to suspend again? You have to look at a series of removals that now constitute more than 10 instructional days, and look at what was the student's behavior. Was it substantially similar to the behavior in previous incidents? Well, I was trying to describe, I don't know if I did a very good job, but trying to describe different behaviors each time, okay? And separated sometimes by at least a month, sometimes 2 or 3 months. So the additional factors such as the length of each removal, cumulative amount, and proximity of these removals to each other. The school could look at this and say, it's not a disciplinary change of placement. And they could go ahead and suspend again. However, any further suspensions, you have to provide educational services. You cannot suspend beyond that. Most schools, however, will err on the side of just looking at this and say, okay, at this point we need to do a manifestation determination, because this next step of conducting a manifestation determination is only required if the school is taking action that constitutes a disciplinary change of placement. So, if it's not a removal, if it's not a disciplinary change of placement, but we're looking at more than 10 cumulative days, okay? You look at the regulation here, Indiana Code 511 IC 7-44-3, that the school, and this is school personnel, in consultation with at least one of the student's teachers. So these decisions are typically made by a principal, talking with the teacher. The school makes this decision. This is not, at this point, a case conference decision. They can decide that the extent to which services are needed for the student to continue to participate in the general education curriculum, although in another setting, and allow them to still make progress towards the goals in the IEP. If the decision is made for a removal that does constitute a change of placement, then the school has to notify the parent and provide the parent with their written notice of procedural safeguards. And this notice must be provided on the date that the school decides to make a removal that constitutes a disciplinary change. Okay, at this point now, if you're talking about making a disciplinary change of placement, like I said, most schools that I talk to and that I've seen will go ahead with the manifestation determination once we hit that 10 days, or we're looking at going beyond 10 days without always going through the hoops of saying, oh, well, was it disciplinary change of placement, looking at the series of removals and how they relate to each other. But that's in there, and if you don't conduct the manifestation determination at 10 days, you better have written documentation that you did jump through the hoops and how you made the decision that it was not a disciplinary change of placement. So within 10 days, you have to convene the case conference, and the case conference has to then determine whether or not the behavior that the student engaged in was a manifestation of the student's disability. Okay, so the case conference should review all the relevant information in the student's IEP. Consider input from the parent, from the teachers, from other school personnel, people who are part of the case conference, and determine two things: whether the behavior was caused by or had a direct relationship to the student's disability, and also, and this is the part that some schools seem to forget, was the student's behavior a direct result of the school not implementing the student's IEP? Because sometimes the adults aren't doing what they're supposed to be doing, and then you expect a student to act appropriately if we didn't provide those services. So those are two parts of it. You know, we recently had a due process hearing where a student had been engaged in behavior, and the case conference did decide that the behavior was a manifestation of the student's disability because the school failed to implement the IEP. Then they go to hearing on some other issue, and the hearing officer, in looking at that, wanted to kind of reopen that and say, well, the hearing officer didn't think that the behavior was a manifestation of the student's disability. But at that point, it wasn't the hearing officer's call, okay, and it wasn't an issue for hearing. So we need to remember that we can determine that sometimes the behavior is because we didn't do what we were supposed to do in implementing a student's IEP. So what do we do if the conduct was a direct result of the school's failure to implement the IEP? School, you need to make some changes. You need to take whatever steps you need to do to make sure that everybody is on the same page and is implementing that IEP. If the behavior was a manifestation of the disability, which would be a consideration here. I mean, if it was because of failure to implement, you make that decision as well. You still have to, you return the student to the previous placement. You can't go ahead and suspend or expel the student. Unless, of course, if the student's behavior here was related to drugs, weapons, or inflicting serious bodily injury, and then the student, regardless of whether the behavior was a manifestation of the disability, can be placed in an interim alternative educational setting for up to 45 days. Serious bodily injury is more than just, oh, somebody hit me and it hurt. Okay, you look at the federal definition, the state definition. I mean, this is serious, like life-threatening, maiming somebody, a loss of a limb, like not a tree limb, an arm or a leg, a loss of an eye, ear, something like that. So we're talking about something pretty serious, not just that the kid got in a fight and another kid got hurt. Okay, if the behavior was a manifestation of the disability, you have to conduct an FBA and develop a BIP, unless you have really recently, you have good data on a recent FBA. But regardless, even if you did do this recently, you should take a look at it again, because obviously, something's not working right here. If the behavior is continuing or escalating. So review and revise that. Do we need to make changes to the BIP? What you want to do is be sure to address the behavior to try to ensure that it doesn't recur. If the conduct is not a manifestation of the disability, school can go ahead and suspend or expel that student further. However, the case conference needs to determine appropriate educational services to be provided to that student during any period of suspension or expulsion that exceeds 10 instructional days in the school year, to enable the student to continue to participate in the general education curriculum, although it's going to be in another setting, probably, to make progress towards meeting the student's IEP goals, and again, to receive an FBA and behavior intervention services that are designed to address the behavior so it doesn't recur. This, again, is another piece that I often don't see. Okay, yep, we decided the behavior was not a manifestation. We're going to expel the student or suspend the student further, and we place the student on homebound. We're providing educational services. But we're still not addressing the behavior. What are we doing to make sure that when the student returns to school that the behavior is going to be addressed? Okay, that is a big piece that I often see missing in when we get complaints concerning discipline. Okay, sometimes schools think that, well, yeah, that's fine and dandy, but this kid doesn't have an IEP. He's got a 504 plan. Okay, I'm going to tell you this whole concept about the manifestation determination came out of guidance from OCR well before it was in the IDEA regulations. So OCR determined, first of all, for kids with that had disabilities, that you could not suspend or expel beyond 10 instructional days if the behavior was a manifestation of the student's disability. So that is true as well for a student who has a 504 plan, even if they're not eligible under Article 7 in the IDEA. That prior to taking any action that constitutes a significant change in placement of a student with a disability, the 504 regs at 34 CFR 104.35 require that you conduct a manifestation determination. In essence, you need to do some sort of evaluation to determine whether this was caused by or a manifestation of the student's disability. And this is because this particular regulation requires that a school evaluate the student before you make a significant change in the student's educational placement. And suspension or expulsion beyond 10 days in the school year is a change in the educational placement. Okay, so under 504, your manifestation, again, the first step includes a determination by a group of people who are knowledgeable about the student. One of the things you'll find when you look at 504 regulations is that they do not identify who these people are. If you look at Article 7 in the IDEA regulations and they talk about a case conference committee or an IEP team, that has to include, the public agency representative, at least one of the student's general education teachers of the students participating, the student's teacher of record, the parent. You have a list of mandatory participants. These are the people that have to be in a case conference, and then there are a list of a bunch of other people that might be, depending upon the purpose of that case conference. When you look at the 504 regulations, they only speak to a group of people who are knowledgeable about the student. And I will tell you that nowhere in the 504 regulations do they specifically require that that group of people who are knowledgeable about the student include the parent. However, I would tell you, you are asking for trouble if you exclude the parent from this group of people that are going to meet to evaluate, to review a student's plan, to determine manifestation, to develop a 504 plan or whatever. The parent always needs to be at the table with you. So, if it's determined that the misconduct is not caused by the student's disability and the student's eligible under 504, but not under Article 7, okay, only 504 eligible, then you can suspend or expel that student just the same way that you would for any other student that didn't have a disability, and 504 does not require that educational services be provided during that period of suspension or expulsion. Unless whatever your procedures are. If you provide educational services or make education available for non-disabled students who are suspended or expelled, then you make those services available to all your students. But if you don't provide educational services for students without disabilities who are suspended or expelled, then you do not have to provide services during that time for a student who is eligible for a 504 plan, as long as they don't also have an IEP, okay? So, interim alternative educational setting, I mentioned this earlier. The principle of this placement, this is a unilateral decision that can be made by a principal only for a student who carries a weapon, carries or possesses a weapon at school, on school property, at school function, uses illegal drugs or sells or solicits controlled substance, or inflicts serious bodily injury on another person. Okay, make sure that those criteria are all met. Principal can make the decision to remove the student to an interim alternative educational setting, but then there are other steps that kick in. You have to notify the parent of this and provide a parent with the notice of procedural safeguards. That's the NOPEs up there. The manifestation determination must be conducted. Even though this is going to happen, you still need to do a manifestation determination, and it's the case conference committee that determines what that interim alternative educational setting is. Okay, services must still be provided during that time that the student is placed in an interim alternative educational setting. Again, allow the student to participate in the general education curriculum, that allow the student to make progress towards the IEP goals, and receive the functional behavioral assessment and a behavior intervention plan here to try to address the behaviors. We want to always remember to address the behavior to try to ensure that it doesn't recur. Well, an interim alternative educational setting, that kind of runs the gambit of sometimes schools put the student on a homebound program. Services might be provided at a library. Some schools actually have alternative programs, or you pair up with another school or a public school corporation or whatever that might operate an alternative educational program that a student can be in. So there's still some working with an association. Sometimes, having that access to their peers doesn't happen, or doesn't happen very much, or as creative as your case conference wants to be in trying to address that. The services might not be identical, but you still have to allow the student to progress in the general education curriculum, progress towards the goals that are in the IEP, and make sure you're trying to address that behavior. all right, is this the sped expulsion? Is this the question here? And what happens after that 45 days is up? Okay, after the 45 days is up, and depending upon why the student was placed here. Okay, this is not necessarily the expulsion, okay? And this only applies in these very limited situations, okay? There are other laws that apply as well. There's the GunFree School Act that requires that a student who brings a firearm to school be expelled for a year. I see some strange looks here, surprise looks, okay? So schools should have policies that provide for that. However, that law also says that the superintendent or the superintendent's designee, I believe, can modify that on a case-by-case basis. A number of years ago, I received a call from a superintendent who's sitting there and said, Dana, I know the law says that we have to expel the student for a year. He said, but do we have to? He said, it's hunting season. We're in a rural community. This kid, you know, a good student, he's a senior. He drove the family's pickup truck to school Monday morning. And, you know, in the gun rack in the back of the pickup truck, yep, there's the hunting rifle. Okay? It's sitting out in the school parking lot, and do I have to expel him for a year? He was out with his dad hunting, just totally forgot that the gun was still in the car, in the truck, and drove it to school. So I'm sitting there and said, no, if the law says you can modify that on a case-by-case basis, I said I would suggest at this point you call his dad, have him come to school and get the gun, that you impose some sort of discipline on the student, you know, make him come in for Saturday schools, make him serve a detention, you know, do something so you make him sit up and take notice and take responsibility for failure to realize that he had the gun with him. But you don't have to do that, okay? But you also don't have to put the student in an interim alternative educational setting but you can when, you know, if you can do this even if the behavior was a manifestation. Okay, so let's talk about that situation. If the behavior was a manifestation, then you can't expel the student. But you can, if he engaged in one of these behaviors, put him in an interim alternative educational setting for a period of up to 45 days. It doesn't have to be 45 days. It can be something less. But I think oftentimes we look at the longest and we go with that. But as we're approaching the end of that time, and remember, we should still be trying to address the behavior, okay? Depending on what it was, if he had inflicted serious bodily injury, and if you really have a fear that this behavior might continue and it would be a danger to bring him back, you can do one of two things. You can go to court to seek an injunction, or you can ask for an expedited due process hearing to ask a hearing officer to extend that placement for another 45 days. So those are some of the things you can do. If the behavior was not a manifestation of the disability, you don't have to put them in an interim alternative educational setting. You can expel the student. But during that, and it would follow whatever your procedures and policies are for all students, you know, what that length of time is. When I talk about the student discipline code, that applies to school corporations, and you might look at that, and even though your charter school, develop a policy that is similar to that. Have something that talks about the period of expulsion not exceeding that semester or school year, and that if the student's expelled during the first semester, the expulsion could continue into the second semester. But if the expulsion occurred more than 3 weeks before the end of the first semester, you're supposed to review that again at the start of the second semester and decide whether the expulsion would continue. So you can go ahead and expel the student. But if it's a student with a disability, you still need to be providing educational services to enable the student to participate in the general ed curriculum to the extent that they were, that will provide the special ed and related services, that will allow the student to make progress towards their goals, and again, that you're going to have the FBA and the BIP to address the student's behavior in implementing those types of services. The question is, if the student's on homebound, is there a minimum number of hours of instruction that need to be provided provided? And no, there's not. Many, many years ago, and I don't know that any of you are as old as I am, so you probably weren't doing this back at the time, but back in the days when our special education regulations were referred to as Rule S1 and Rule S5, we did have times in there, and those have been removed probably back in the early 90s is probably when they were removed. And at that time, it required that the homebound instruction be, I think it was 5 hours a week for a student in elementary school, but for a secondary student, it was 1 hour a day per class subject that the student was taking. So, which could be more than the length of some kids' instructional day. If I'm taking 7 subjects, that means 7 hours of homebound instruction per day. So no, it's not in there. This is going to be a case conference decision to determine what services does this student need. And students are functioning at all sorts of different levels. Some students can do this with, a couple of hours a day, some with something less, some require something more for them to get it. And you can be creative. Sometimes you can let students participate by Skype in the classroom and still be there, or some other electronic means. So, and then, and other virtual learning options, and that's not my area of expertise, but you can talk with Tracy or somebody else at the department about virtual learning options that are also available. Okay. If a parent disagrees with your determinations about manifestation determinations, the parent has the right to request a due process hearing. And if a parent is challenging the determination about manifestation or a determination to suspend or expel, then that hearing is an expedited due process hearing. For expedited hearings, the procedures are, for the most part, the same, just with timelines shortened, and there are no extensions of time in the hearing process granted. The parties can agree, however, but it takes the agreement of both parties to take the hearing out of the expedited process. So a school also has the right to ask for an expedited due process hearing if, and this is kind of in response to the question over here, what do you do if at the end of at the end of the alternative educational time setting, you think it's still dangerous for the student to come back, you can ask for a due process hearing, an expedited due process hearing, or if you think that maintaining the student in the current educational placement is substantially likely to result in injury to the student or others. Okay, like I said, procedures are very similar, except that the hearing has to be held within 20 instructional days of when the party requested the hearing. Decision then has to be issued within 10 instructional days after the date of the hearing. The resolution session, it shouldn't say session, it's a resolution meeting, has to be held within 7 calendar days. Normally it's 15, and there are no extensions of time. And parties can waive that, but it takes both parties agreeing to take it out of the expedited process. One of the rather curious situations that can arise, though, with an expedited due process hearing is that the timelines here are all speaking about instructional days. Okay, timelines for a normal hearing are pretty much double what's up here, but it talks about calendar days. So we did have a situation come up once, and I was ready to jump all over our hearing officer for missing timelines because the parent requested an expedited due process hearing in May, and the hearing officer sets it for hearing sometime in September. I'm sitting there thinking, you're well beyond 20 days, and then it's like, oh, but it's 20 instructional days, and the request for the due process hearing came up right at the end of the school year. So like, okay, so we had 2 or 3 instructional days there, and then we don't count the rest until sometime in August when school starts up again. So in that situation, even though it's an expedited due process hearing, it can actually take longer than one that wouldn't have been an expedited due process hearing, except for the fact that most of the time with our due process hearings, one side or the other asks for an extension of time, so they end up taking longer. Okay, questions on discipline before I start talking a little bit about our due process procedures? Okay, regulations speak to basically three types of dispute resolution here. So we have complaints. For complaints here, in the federal regulations, they are referred to as state complaints, mediation, and then due process hearings. And in the federal regulations, this is referred to as a due process complaint. So, complaints pretty much are allegations that a school has failed to follow appropriate procedures. You didn't dot every I, cross every T in developing the IEP. You didn't give notice to, appropriate notice to the parent of a meeting. You didn't give notice before implementing an IEP. You didn't implement the IEP appropriately, and that is probably the most common complaint that we have, is that the school failed to implement the IEP as written. This is in the federal regulations. It is not in the statute. So I'm trying to give you some of the citations because we generally refer to Article 7. A complaint can be filed by anybody. It does not have to be the parent. And it has to be in writing and it has to be signed, but it can be submitted electronically through our electronic online system, ByChamp, that Stephanie will talk to you about later. We will not accept it by email. You can print it out, sign it, and fax it to us, or mail it to us, or submit it to us through our electronic system. What happens when we get a complaint? We go through a variety of steps here that we have some very definite procedures and timelines about what we have to do. We send a preliminary letter that's going to notify the school, and a copy always goes to the complainant that we've received this complaint, and we're going to tell the school you have 10 days to take one of these actions. One of the actions is doing nothing. You don't have to do anything, but in this first 10 days, you can try and resolve the dispute with the complainant. You can agree with, if the complainant is the parent, with the parent, to engage in mediation to try and resolve it. You can enter into a written settlement agreement with the parent. You can file an answer, a response, or tell us you're not going to do anything and go ahead and investigate it. Okay? After the 10 days, we send out an issue letter where we have identified what we've determined the issues in the complaint to be. Okay, so during that 10 days, when we say, hey, you've got 10 days to try and take one of these actions if you want to, we don't sit around and do nothing, okay? We're going to be calling the complainant, and we're going to be talking to your special ed director and try and ferret out what the issues are. We're going to make sure that both of you are aware of the fact that you can communicate with each other and you can try and resolve the issues. Okay, and probably a good half of our complaints do get resolved in some way, that the school reaches out to the parent and says, hey, yeah, you know, you're right, we didn't do this right, or we didn't do this, let's reconvene the case conference, let's revise things, let's go on. Whatever you do, that half of them either result in a written agreement or with the complainant withdrawing that complaint. If the complainant is not the parent, we will probably also notify the parent that this complaint has been filed. It makes it more difficult in our communications with the complainant because we cannot share information about the student with the complainant. You know, so if they filed a complaint about Johnny over here, you know, we cannot turn around and tell the complainant, oh, well, now the school did this with Johnny, or you know, we can't do that. So it becomes more difficult, and sometimes we depending on what we end up in putting in a complaint report, because the complainant knows who the student is, we've had, I think, only one situation where in our written complaint report that we not posted it because it would disclose personally identifiable information about a student to the complainant, who is not the parent, and we didn't have written consent of the parent to disclose that information. But generally, we try to make sure that our complaint reports don't put out any information about the student. We do identify the name of the school corporation in the very first sentence of the report. Other than that, we refer to the school as the school. We refer to the student as the student. We don't typically identify a grade level or the student's disability or which school within a school corporation. Now, I know for a charter school that's you're not typically like a school corporation, so you don't have like half a dozen elementary schools and a couple of middle schools and one or two high schools. You just have the one school. But we try and be real careful that we're not going to be disclosing personally identifiable information. So if it gets to the point where we send out the issue letter, we're going to, in that issue letter, say, school, these are the issues. We might ask for certain documents to give us, but then there's always going to be a catch-all, like any other documentation that you have to show, to respond to these allegations or to these issues to show that you did what you were supposed to do. Within 40 days of when, and this is 40 calendar days of when we receive the complaint, then our complaint investigation report is due out. Okay, federal regulations allow 60 days, but Indiana, in our procedures, we do allow for a period of reconsideration. So the federal regs require that within 60 days we get a final report out. So therefore, our initial report is due out in 40 days, and this is to allow for that reconsideration period. So if either side asks for reconsideration, you must do so within 7 calendar days of receiving our report, and then we still have to meet that outside 60 days. If reconsideration is asked for, then that reconsideration goes to the Director of Special Education, who is Dr. Pam Wright, and she will review everything, and she makes the final determination about whether the report stands or if some changes need to be made. If we find there are violations, we are going to require corrective action. Now, sometimes during the investigation, a school will take ownership that said, yep, we messed up and we're offering to do certain things, or we've already done this to take care of it. Sometimes we'll look at that and say, yep, there was a violation here, but the school has already done this and no further corrective action is required. Sometimes we'll look at that and say, that wasn't enough. You need to do more. We have, for charter schools, in a couple of instances, we have required that school personnel attend this training. Not necessarily this one today, but the charter school training that we put on, because we felt like there seemed to be, in a few instances, a little bit of disconnect about understanding what the responsibilities are. So we have an obligation under the federal regulations as well to make sure that all public schools are implementing all the requirements of the Individuals with Disabilities Education Act. So we're not doing this just to pick on you, we're doing it to fulfill our statutory and regulatory responsibilities. So sometimes the compensatory or the corrective action that we require might be provide some additional services to a particular student. Sometimes it's just, hey, send around a memo to all certain staff of people, reminding them of their responsibilities to do certain things. It might be you need to review and revise your policies. It might be, oh, you don't have policies, you need to develop policies and procedures addressing certain areas. So it all depends on what it is. Our complaints, our reports are posted online, so if you want to go look at them, look at our special ed web page and due process, and you can find all those. A complaint can also be used to enforce an agreement that was reached in a prior complaint, and we did have that happen one time where, a parent filed a complaint, parties reached an agreement, the complaint was withdrawn, then a couple months later the same complainant files another complaint and said the school didn't do what they said they were going to do. So that can happen. A complaint can be used to enforce a mediation agreement, and a complaint can also be used to enforce a hearing officer's decision. I'm not sure that we've ever had someone do this, because part of our process too is we try to make sure after a hearing officer has issued a decision, we do have one of our complaint investigators monitor that order, monitor the school to make sure that they complied with that order, although it would be possible that we missed something. Mediation agreements can also be enforced directly in court. They don't have to come to us first. Okay, mediation is a voluntary process. Okay, both the parent and the school have to agree to engage in mediation. We cannot force a party to go to mediation, but mediation, as we just talked about, can be used if the parties agree to resolve issues that arise in a complaint. Mediation can also be used to resolve issues that are pending in a due process hearing. So all three processes are related to each other, or interrelated in certain ways. However, one does not have to progress from one to the next, okay? You don't have to file a complaint before you can go to mediation, or file a complaint before you can go to a due process hearing. Each of them are their own standalone process. Okay, mediation is voluntary. You will be assigned an impartial mediator. Okay, our mediators are all certified mediators. They're on the Supreme Court's registry of mediators. They are all attorneys, although we don't currently require that, but they do have to be a registered mediator, either a civil mediator. Civil mediators in Indiana do have to be attorneys, and all of ours currently are civil mediators. Then there are also domestic relations mediators, and those individuals still have to go through the training to be a mediator, but they aren't required to be attorneys. But the goal of mediation is to help the parties to reach their own resolution, to come to some agreement. Mediation is the only one of these processes that really allows the parties to take control of the outcome here. Okay, you file a complaint. If that runs through its whole process, you have a complaint investigator, you have the Department of Education who's going to make a determination whether or not there was a violation, and who is going to make the determination about what happens after that, what the corrective action is. If you go to a due process hearing, you're going to have a hearing officer who's going to make a determination about what happened here, and is going to order whatever the hearing officer orders. So mediation is the only one of these processes that really allows the parties to sit down and take ownership of the solution. A school can request mediation, a parent can request mediation, but we will not assign a mediator unless the other party also agrees to participate. So we would encourage, you know, if you think mediation might be a good idea, I would encourage you to reach out to the parent, so when you submit it to us, you've got the signature of both the school and the parent saying, we're requesting mediation, then we'll assign a mediator. However, I don't know that we typically get it with just one signature from schools so much, but we do oftentimes get a request for mediation coming in from a parent, where just the parent has signed, in which case then we'll either try to get the parent to, hey, take that to the school and see if they'll agree, or sometimes we'll send it to the school and say, we received this, you know, would you agree to participate in mediation with the parent? Because unless we get both signatures, it doesn't move any further. You know, we don't assign a mediator. So mediation, it's voluntary, and both parties have to agree. Okay? Complaints and hearings are not voluntary. You know, somebody asks for, you know, somebody files a complaint, you've got to respond to it some way. You know, somebody requests a hearing, whether it's the school or the parent, the other side's there. You know, you're going to have a hearing. You can't, you know, you can get out of it by reaching an agreement with the other party. But you can't just make it go away by saying, oh no, I don't want a hearing. If the school asks for it, then it's going to be there. If the parent asks for it, you know, it's there unless you reach out to the other side and can resolve it. So what are you doing when you have a student who has maybe gone from school to school, and now they've landed at your charter school, and they know that this is probably their last option? You know, a number of years ago, Kathy Daniluk, who's our state attendance officer, and I were tasked with investigating some situations of some allegations of charter schools pushing kids out after count day, and then would go back to public schools. So we went around and investigated and talked. So we got a chance to talk to a lot of charter school administrators, and going around to visit a lot of charter schools, which was very interesting to me, very eye-opening and very, very good, a very good experience in finding that more often charter schools were after count day taking in many more students from public schools than the numbers of students that were leaving charter schools to go back to public schools. So our findings were kind of going backwards the other way. But this is where I really learned and understood more, a little bit more about, certainly I don't see it to the extent that you folks all do, but to understand this concept of the numbers of students, especially probably in central Indiana here, that are mobile for a variety of reasons. They've lost their housing, they're homeless, they're living with friends, they move around, in addition to those kids that get in trouble at one school and then go to another and go to another and go to another. When I talk about the disciplinary rules of Indiana Code 20-33-8 that talks about student discipline, one of the sections in there does say that for a public school corporation, that if a student has been expelled, is under an expulsion from another school, or withdrew from that school to avoid an expulsion, that another public school corporation doesn't have to take that student in. They can honor that expulsion, or they can honor that proposed expulsion. And what I find is most charter schools are taking those students in, which is good because that particular statute doesn't necessarily apply to you, but it's also good because it's the right thing to do for kids. It's better to have these kids in school and rather than being on the street and getting in further trouble and whatever, and you can hopefully do something. But when you start out like, are we seeing situations where we have a parent who's learned the system is filing complaints with us on the same student and involving various schools because we've gone from one to another? I don't know that I've seen that, but I will ask Stephanie to look into that because she's our iChamp person and she can do the search to search by students' names as well. I'm not necessarily, just anecdotally, I can't sit there and say that, oh yes, here's Johnny, his parent, this parent filed a complaint. Yes, we do have repeat offenders, if you will. They're not offenders really, but repeat filers, okay? That we do have some parents who have filed multiple complaints, but I'm not necessarily feeling like it was against multiple schools as we moved a student. It's more like, for some reason I've got a beef with your school and I filed a complaint, and 6 months later I'm filing another complaint, and then another and another. We have one parent who filed probably within a course of 6 months 5 complaints against a particular school. We didn't find violations on any of them, but she kept filing because for whatever reason she's angry at the school. But her anger at the school seems to be more or disagreement with what they're doing, how they're treating her versus how anything that they're doing for the student, okay? None of the issues really had to do with, failing to provide appropriate services to her kid. It was not, she didn't like the way she was being treated, and most of them weren't violations or weren't allegations of Article 7 violations. For those schools that are having difficulties, who are having, it's one thing to sit there and say the parents filed 5 complaints and we've not found that you've done anything wrong, but we might also have, we've had 5 complaints against your school and we're finding violations all the time, okay? We have tried to reach out and what can we do to help you, okay? Maybe not right now during this course of this investigation because I have to try and maintain this impartiality of looking at the parent's complaint, but after this is all over, we have had our complaint investigators maybe go out to the school corporation and meet with the teachers and the parents, and I know a couple of years ago that Tracy went out and talked to a school corporation, had several meetings with parents and teachers and to get everyone together and to try and resolve some of these things. Stephanie's gone out to, I believe, one of the charter schools to try and go through the process and explain some things. So we want to try and help you, okay? We're not trying to be the police that are going to come down heavy-handed on you, okay? Although so at times you might feel that way, and I get that, because we're trying to fulfill our responsibilities as well. But we also want to try and be helpful, because we always want to keep in focus the students, because this is why we are all here. We want to do what's right for the students, for the kids, and to make sure, and part of that is procedural. And I know there are times when maybe you didn't necessarily follow all the procedures, but the end result was good. You had good services here for the kid, but maybe you didn't dot every I and cross every T. I have said for years when I talk to people that there are so many regulations here for special education and all the procedural things that you could probably walk into any school, not just a charter school, but any school, and look at any kid's special ed file and find something that's not quite right. Okay, does that mean that the student was denied a free, appropriate public education? Not necessarily. Okay, it depends on what that violation was, what it was. We have had a complaint where a parent would say, the school didn't give me prior written notice about this case conference committee meeting. Okay, you're supposed to give written notice to a parent prior to the case conference, notifying the parent of what this meeting is about, and to give them that notice sufficiently in advance to ensure that one or more of the parents can attend. Okay? So you have a situation where school called the parent and sit there and say, yeah, September 13th sounds great. Yeah, I can meet there and we'll do that. Then on the morning of September 13th, I sit there and say, oh, I'm going to call the school. I'm sorry, I've got a sick kid. I can't make it today. Can we reschedule it for tomorrow? And school sits there and says, well, let me check. Let me see if I can get everyone together. Call me back and say, yep, tomorrow works just fine. So tomorrow comes, I go to the meeting and everything. Now, a couple months later, I get angry about something else entirely, and I filed that complaint and said, you didn't give me prior written notice of that meeting on September 14th. The notice you gave me said the 13th, and you rescheduled it, and you didn't give me written notice. Now, I was there. You rescheduled it at my request, but that's technically a violation because you still didn't give me that written notice of when that meeting was going to be. We've had that type of thing happen, okay? That is, in my opinion, a waste of everybody's time to have to go through and investigate a complaint like that and for a school to respond to that. Okay? You gave them written notice of the case conference. It's just that the date changed, and it was at the parent's request, and the parent was there and fully participated. So there was no substantive violation. There's a technical procedural violation. And that type of thing did not result in a denial of a free, appropriate public education to the student. But we do have those types of complaints that happen sometimes, but not really very often. All right, so mediation, we assign mediators on a rotating basis. Parties to mediation are the parents and the public school only, okay? A third-party complainant cannot be a party to mediation. Now, who can actually participate? That's up to the parties, okay? Both sides need to have somebody at that mediation session who would, in essence, be on the school side, be a public agency representative. Someone who can reach an agreement and commit resources and make those decisions and make a decision that would be binding, okay? You do no good to come to mediation if you have somebody there who sits and says, well, I can't make a decision. I've got to take it back to my director. I have to take it back to the principal or somebody else. Well, then you're wasting everybody's time at mediation because you can't actually get resolution. Okay? Mediators have to be qualified and impartial. Okay? Impartial is, just really that don't have any conflicts of interest with either the parent or the school. The qualified means they've been through our training and they have to be a certified mediator. Okay, discussions that occur during mediation are to be kept confidential. When parties agree to go to mediation, the mediator will explain all of this, and she will have everybody sign an agreement that they understand what the process is, and that conversations that occur during mediation will be kept confidential and cannot be used as evidence in a future due process hearing or court proceeding. If you reach an agreement, or sometimes an agreement can be a partial agreement, not on all issues, but part of it, it will be reduced to writing. and the parties all sign this agreement, and it is enforceable in federal or state court or through the complaint process. You need to understand signing the mediation agreement is binding at that time that you sign it. Okay, sometimes people try to come back and say, oh, well, there's a 3-day rule. I have 3 days to renege or change my mind. No, you don't. Mediation agreement is binding when you sign it. Okay, people who say the 3-day rule are confusing that with the hearing process and a resolution meeting. If you reach agreement in a resolution meeting and a hearing process, that resolution agreement, parties have 3 days to change their mind on. So, but mediation is binding at the time you sign it. Okay, so due process hearings, that's our third process. And this is where you're going to have an independent hearing officer. Independent hearing officers are administrative law judges, okay? It's just our terminology in special education refers to the administrative law judges as independent hearing officers. Here, hearing officers can't address anything, okay? While the feds will say that through the complaint process, the parent can raise any issue, even the appropriateness of proposed services. We really have a hard time addressing that in a complaint process. But hearing officers are going to hear testimony under oath, so they'll get written documents as exhibits, they'll get testimony of witnesses, so they can address any dispute involving the provision of a free, appropriate public education. The request has to be in writing, signed. It has to include the student's name, where they go, and some sort of factual allegations about what this is all about, and a proposed resolution, at least to the extent that the parent has an idea of what that might be. Has to be served on the opposing party. Okay, sending it to us is not enough. I mean, it kind of does, but your timelines don't really start until you serve the other party. Sometimes parents send it to us and forget to serve the school. Sometimes schools send it to us and forget to serve the parent. It's just the same as initiating any other sort of action that you have to serve the opposing party, either in person or by certified mail. If a parent is the one requesting a hearing, you're supposed to inform the parent of the availability of free or low-cost legal representation. That's always been a difficult thing for schools to do because there really aren't very many people that are doing this at free or low cost. You can reach out to Indiana Disability Rights. There's I don't know, we have 2 or 3 places listed in our Notice of Procedural Safeguards and in navigating the course at the end. So, procedural requirements, the request has to be sufficient. It has to include all those pieces of information that I just mentioned about the student's name and school they attend and their address and what the issues are. There are particular timelines. I'm not going to go through all of this, but it's in Article 7. A resolution meeting and a resolution period. If the parent requests a hearing within 15 days, the school is required to conduct a resolution meeting with the parent. There's no provision in the rules for extending that timeline. So within 15 days, that's a requirement on the school to hold that resolution meeting with the parent. If the school is the party that requested the hearing, there is no need for that resolution meeting. It's not required, and the 45-day timeline for the hearing starts upon your service on the parent. If the parent requests the hearing, there is a 30-day resolution period, first of all. In the first 15 days, that resolution meeting is to be held. After the 30 days, if you've not been able to resolve it with the parent, then the 45-day hearing timeline starts. Schools, including charter schools, are responsible for paying the cost of the hearing officer, for paying the cost of the court reporter, for paying the transcript, and if the parent's the prevailing party, you pay the parent's attorney's fees as well. So hearings can end up being extremely costly for schools. Rights of parties, oftentimes parents or people talk about parents' due process rights. Most of the rights are rights of the school as well. They are rights that accrue to both parties. You have the right to be accompanied by legal counsel if you want, or somebody else who's knowledgeable about the process. You have the right to present evidence, confront and cross-examine other evidence, to compel the attendance of witnesses. You can ask the hearing officer for a subpoena if necessary. You have the right to conduct some discovery under AOPA. AOPA is the Administrative Orders and Procedures Act. certain trial rules. The trial rules that apply to discovery are applicable, and Article 7 are special education regulations. You have the right to prohibit the introduction of evidence that wasn't disclosed to you at least 5 days before the hearing. You have the right to ask for a separation of witnesses at the hearing, so you don't want other people sitting into the hearing listening to what somebody else said so they know what to say. Now, even when you have a separation of witnesses, you can never keep a parent out of the hearing. That doesn't apply, and the school is entitled to not only have their attorney there, but one person to representing the party, whether it's your director or principal or somebody, the superintendent. Typically for school corporations, it's going to be their special ed director. You have the opportunity to receive a verbatim transcript. Now here, it's up to the parent to decide whether that's going to be in electronic form or paper form. Mostly now they're getting it in electronic form, because you get electronic form, it takes up a whole lot less space, and you can always print it out if you want. But if you have it in electronic form, you can also easily search the hearing or search the transcript for particular words or a particular witness's testimony. Again, you have the right to receive a copy of the hearing decision. The parent chooses whether it's, again, electronic or in paper. If somebody needs an interpreter, the school is responsible for the cost of the interpreter, whether this is a language interpreter or hearing impaired for American Sign Language. Now, the additional rights of the parent, it's up to the parent to decide whether or not the student would be present. That's the parent's choice solely. The parent decides whether the hearing will be open or closed to the public, because that's a matter of disclosing personally identifiable information about the student. The parent has the right to inspect and review prior to the hearing all of the student's educational records, and under Article 7, the right to inspect and review the student's educational record prior to a due process hearing when that's been requested also includes the right to receive a copy of the kid's educational record at no cost. So remember that if the parent wants that, you have to give the parent a copy of all the educational evaluations, IEPs, or anything else like that that you have. So, iChamp is our electronic system for filing requests for filing a complaint, requests for mediation, or requests for due process hearing, and Stephanie will be telling you more about that. And we're at the end of my time for this before the first break, and so I'll be back up here afterwards, so you might want to hold any questions you have until after the break, write them down so you don't forget them if you want.